Here's defense that your main concern is that you don't want them to seek to establish that maybe your client was intoxicated.
Correct, Judge.
You're going to try to say that he was intoxicated at the time?
No, Judge, because he's not charged with intoxication manslaughter. He's charged with manslaughter. It's just the fact that he was consuming alcohol and whether or not it could have played a factor in what happened.
All right. So we're going to go on the record.
At first glance, this looked like a routine courtroom hearing. But hidden inside this legal debate was a question that could influence the entire trial. Prosecutors wanted the jury to hear that Alexander Castro had consumed alcohol before driving. The defense feared that one detail could unfairly change how jurors viewed the case. What happened next would spark a heated legal battle over where the line between evidence and prejudice should be drawn.
In 2022 CR 11862, State of Texas versus Alexander Joseph Castro. Can I have parties announced for the record for the state?
Daniel Escobar from the State of Texas.
Sorry, Judge. Gary Hillier for Mr. Castro.
And are you Mr. Castro?
I am Mr. Castro.
All right, so let's first take up defense's motion in limine because I believe State, have you had a chance to review the motion in limine?
Yes, Judge.
All right. And State, do you have any objections?
Yes, Judge, to Section 1 and to Section 2. Both of them talk about impaired and the defendant consuming alcohol. In our indictment, one of the manner means is through the introduction of alcohol. We're not alleging intoxication, but that is one of the manner means that we were trying to go with recklessness. And so the state feels that if we have to be limited in whether or not we can question that the defense has been on notice, well, that would limit us in the presentation of our case.
All right, just 1 moment. Let me pull the indictment.
For second, third, thanks.
All right, so State, my understanding then is you're not trying to say that the defendant was intoxicated?
No, Judge, it's just that one of the ways that he was reckless was that before driving his vehicle was that he was consuming alcohol, that he admitted to consuming alcohol.
All right. And it is in the indictment, counsel. So what is your argument to their argument?
So the first part, Judge, part 1 is our objection to we anticipate the state is going to try to bring evidence that Mr. Castro was intoxicated. So the first bit is intoxication, Judge.
All right, so let's stop there.
And 1 is intoxication.
All right. So are you going to try to say that he was intoxicated at the time?
No, Judge, because he's not charged with intoxication manslaughter. He's charged with manslaughter. It's just the fact that he was consuming alcohol and whether or not it could have played a factor in what happened.
All right. So defense and state, then with regards to the motion in limine, if you are going to seek to establish that he was intoxicated, y'all need to approach before that's done. But if the only issue is going to be that he consumed alcohol before driving, then the court is going to allow that. And it appears, defense, that your main concern is that you don't want them to seek to establish that maybe your client was intoxicated.
Correct, Judge. That's the first part.
All right.
Judge, can I
Yes, you may continue.
So, Judge, the second paragraph is obviously, and of course we object to it in the indictment, but we understand it's part of the manner and means that the state is going to try and establish. One of the standards that the state we anticipate is going to try and prove is that Mr. Castro was impaired through the introduction of alcohol into his body. Now, the problem with that, Judge, it's confusing. It hits almost everything in 403. It's an improper legal standard. It's not defined in the code. It's not defined in case law. So we would be asking the jury to make a factual determination based on a made up or non-legal term. So it's confusing and it would ask for speculation. The consumption, we understand, is a court's ruling, Judge. That's fine. But this impaired word, it's not a legal word. And so we object to any evidence about impairment.
All right. So what happens in courts where there are not legal definitions for words? Do we not use them because there's no legal definition?
I think that's the way that courts, it's defined through case law, Judge, and it's normal usage. But the reason that we object to the word impaired is because impaired kind of synonymous with intoxicated for a layperson. We know as attorneys that according to the code and law, case law, intoxication is very well defined, and it's clear it's under 49.
The argument had now shifted to a single word: impaired. Prosecutors claimed jurors could use the ordinary meaning of the term. The defense argued the opposite, warning that the word could make jurors think Castro was intoxicated, even if no such charge existed. Suddenly, this wasn't just about alcohol anymore. It was about how one word could shape an entire verdict.
For the penal code, but impairment's not. And so impairment in a juror's mind, despite the court's instructions and explanation, could still be the equivalent of, oh, he was intoxicated then. So it's the same thing. It's like saying, using the word drunk.
But isn't that something to handle through cross-examination?
Well, that might be how the court rules, Judge, and, but that's our argument, Your Honor, and we'll leave it to the court to rule.
All right, defense. I'm sorry, state.
And Judge, again, we disagree. Again, the jury would be able to, just because it's not legally defined, they can use the normal meaning of the word. Again, that's something that it's through defense and statements and just the circumstances around what happened. That's at least something that they can make a determination. And again, we're not trying to say intoxication, but again, it's impaired. That's something that, again, that word may not come up.
All right. So with regards to the balancing test on whether or not that line of questioning should be allowed, I'll need to make that determination at the time evidence is presented. So, state, before you have a witness testify that you believe or they believe that Mr. Castro was impaired, we'll just have the jury step out for a moment so I can hear the question and make a ruling with regards to 403. I'm sorry, 403. All right. So on number one, I believe that's been settled. So you can ask questions in regards to whether or not alcohol was consumed. Number two, you'll need to approach.
And Judge, just for the record, so number one was more intoxication, number two was impairment, and number three, I apologize, that was consumption.
All right. So, well, number one, that's been granted. You're not going to try to establish that he was intoxicated. Is that correct?
Yes.
All right. So if something changes in regards to number one, then you all have to approach and we'll handle that outside the presence of the jury. But number one, that will be granted. Number two, you'll need to approach. And number three, defense.
Again, I think I know the court's ruling. Again, it's a 403 argument. We'd ask the court to make a balancing determination to see whether any evidence is the risk of confusing the jury, the issues, misleading the jury, substantially outweighs any probative value at the time.
All right. Well, number three appears to be that you're not wanting the state to mention that Mr. Castro had allegedly consumed alcohol.
Correct, Judge.
All right. Well, that's in the indictment that they're stating that he consumed alcohol. I will, you want a 403 balancing test. Here's the thing. I can't do a balancing test until I hear the evidence, but I will make my ruling when I hear the evidence. But defense, what I'm telling you is the consumption of alcohol is in the indictment. And the state, in their argument, said that your client admitted to consuming alcohol. Whether his admission that the state is alleged he did comes in or not, that's another question. But I really don't see at this point in time how that would be prejudicial.
Again, I just want to supplement that, Judge. I'm sorry, I should have said it before. Case law has established that consumption of alcohol is not illegal. And so to allege that as that consumption of alcohol is a manner of means on its own that is equivalent to recklessness is misleading in itself. And that's my argument, Judge. We respect the court's ruling.
Okay. All right. So with regards to the consumption of alcohol, state when you are ready to ask a witness whether or not Mr. Castro admitted to consuming alcohol, or however you wish to have the evidence presented that alcohol was alleged to be consumed by Mr. Castro. Just approach. And for that part, I'll have you all come forward and I'll do a balancing test.
Yes, ma'am.
All right. So far, does everyone understand the court's rulings? All right, then let's move on to number 4, prior convictions.
Judge, the state's in agreement. The only caveat would be is that if the defendant does take the stand, if there's anything that comes up.
All right, so with regards to prior convictions, if anyone believes that they should be allowed to ask questions about that, just approach before you do so. Extraneous offenses?
Same thing, Judge. If there's any sort of opening the door or that, if the defendant will take the stand, that's.
All right, just approach beforehand. All right, defense, do you have, I know you have the time motion that you wanted to talk about, but before we get to that, any other motions other than that?
That's all, well, for now, Judge, that's all we needed to be ruled upon before we pick a jury. That's it for now from the defense. Thank you,
All
Judge.
right, so then we're going to move on with the state's motion, and they want to have the jury view evidence outside the courtroom. Defense, have you had a chance to review the state's motion?
I have, Your Honor.
All right, defense, are you in objection?
I do object, Judge. Yes, we do.
All right, I'll hear your objections.
Your Honor, and I've got 2 cases for you.
Okay.
And I'll give the state the, it's Andika versus State. And one of the cases is one.
Just one moment. For the court reporter, it's Andika, Andika, the state. All right. Yes.
So thank you, Judge. So we do, we've seen the state's motion and we object. And based on the case that the state cites in its motion, which is Mauricio versus State, and I can give you a citation if you need it.
Yes. And here's the thing, everyone, when you all are saying cases, because we read case law all the time, court reporter doesn't read case law all the time. So if you all could pronounce it and make sure that you, if you want your record to be clear, make sure that you spell the case to the court reporter and whatever site you have.
And it's Mauricio versus State, Your Honor. And it's the citation is 153 Southwest 3rd, 389. And this is the state's own case that they cite. And basically our objection, Your Honor, is that what the state is proposing is an improper demonstration or representation, or some misrepresentation of the scene as it happened on the evening. Now, I don't know what the state is trying to prove by bringing these vehicles here. It's certainly overly prejudicial. It will be misrepresenting the state as it appeared on that day, because obviously you can't recreate, obviously the court doesn't know this, 281 North in the space between the 2 vehicles where the accident crash site was over a quarter of a mile at least. There'll be a misrepresentation of the crash. And it goes to what the court says in Andika, in the case you've got there, Judge, and I highlighted it, that the court, one of the things that the court can consider is the nature or the deterioration of the scene or the items to be viewed. Now, my understanding, these vehicles have been kept in, what's it called? The pound, the SAPD pound, and they've been there for 2 years. So the condition that they are in today is not the condition that they were in 2 years ago. They've been outside, it's grounded, and they're outside. So they will have been exposed to the elements. So they will not look today like they did 3 years ago. And the case that the court, that the state cites, Mauricio, in that case, that was a demonstration. Mauricio was a demonstration where, and this case isn't Mauricio, this is a case where there was an accident. And we're just going to be looking at the vehicles. Now, what the case law says is, one of the things that the court consider, Your Honor, is that whether that evidence can be obtained from more traditional means, such as photographs and videos, which there are in that big box over there, there are hundreds of them.
Okay, so let me just stop you a little bit because I like to take things one step at a time. So it appears your first argument is that the state may be seeking to recreate the scene on 281, potentially.
Possibly, that's correct, Judge.
State, are you trying to recreate the scene? So it appears your first argument is that the state may be seeking to recreate the scene on 281, potentially.
Possibly, that's correct, Judge.
State, are you trying to recreate the scene from 281?
Judge, the reason why we gave notice to both the court and to defense is that you could make a determination as to how we present the evidence. If you say that we need to try and recreate it as best, we can try that. If it's just we bring the cars here and we show them, that's up to the court's determination.
But no, my question is, are you seeking to recreate the scene from 281?
No, Judge, because as defense counsel mentioned, that is a very large stretch of highway. What we would do is trying to just present the car so that they can see the condition that they were in.
All right. So then you're saying that you want to just present the cars so that the jury can see the conditions the cars were in.
Yes, Judge.
The battle inside this courtroom was no longer just about legal arguments. Prosecutors wanted jurors to see the actual vehicles involved in the crash, arguing that photographs could never reveal the true scale of the damage. The defense pushed back, warning that the wrecked vehicles could create emotion instead of facts. Now, Judge Boyd faced a critical decision that could shape how the jury views the entire case before a single witness even takes the stand.
All right. So then his next argument, and correct me if I'm wrong, he's saying that because the cars have been at the pound in the element, and I don't know if they've been in the element or if they were covered or not, but he's saying cars have been at the pound for over 2 years in the elements. Are those cars in the condition they were in at the time of the alleged crash?
My understanding, Judge, is that they've been left grouted and that no one has gone in and done anything to the cars.
But have the elements changed?
My understanding, Judge, is that they've been covered in plastic and that they have been covered.
All right. So the first thing that the court will need to know, and there will need to be witnesses, I'm assuming, for this to say that the cars were protected from the elements.
Yes, sir.
Because I can understand if the
Thanks for watching and subscribe my channel